I have not signed a motion to withdraw.
This is Matthew Mansour, Assistant Public Defender with on behalf of Mr. Kyle.
Right away, this hearing opens with procedural tension. The judge makes it clear he has not signed the motion to withdraw, which means the public defender is technically still the attorney of record. That's a critical point in courtroom procedure. Until a judge formally approves withdrawal, the defense attorney remains responsible for representing the defendant. Now the court is dealing with two separate issues simultaneously: the withdrawal request and a forfeiture motion filed by the prosecution. A forfeiture motion often arises in cases involving allegations like witness tampering or intimidation, where the prosecution argues that the defendant forfeited certain rights through misconduct. But here's where things immediately get complicated. If the defense attorney withdraws, the defendant could suddenly be left without representation during a key motion hearing. Judges take that situation very seriously because defendants have a constitutional right to counsel. So before anything else happens, Judge Simpson is essentially trying to determine a simple but critical question: who is actually representing the defendant today? If the public defender is still on the case, the hearing should proceed. If there's a legitimate conflict requiring withdrawal, the court may have to delay everything. And that's why the judge immediately asks whether the prosecution is ready to argue the motion, because the court schedule assumes both sides came prepared.
I have this motion. Well, I have two things up because I have a motion regarding forfeiture. Ms. Ford, are you ready to argue that motion? Yes. Well, I've got a problem here because I'm trying to figure out what happened on the public defender's side.
Your Honor, I can explain that. I was appointed to represent Mr. Kyle on this motion hearing today.
You mean assigned? Your office has been appointed from the get-go.
Yes, I was assigned to represent Mr. Kyle this motion today. I have sent a conflict check to our office this week because of his new charge that he has picked up, the witness tampering charge. And while waiting for the conflict check to come back, either confirming that there is a conflict or not, I was prepping for this call. Just up until yesterday, our office has sent an email saying there is a conflict, please withdraw.
Takima LaShawn Cooper wasn't involved in the case before the other matter?
Takima Cooper is his mother, and she is a suspect in the new charge.
So why would that cause you to withdraw in this case?
Your Honor, I don't handle whether it's...
Well, somebody needs to get here and tell me, because here's the problem. As of the 4th of April, there was no conflict. Right? It comes down I think it was the 23rd of April. Then his exam is set before me. There's then a request for an adjournment. No mention of any conflict at that point.
Correct.
Then I don't get notification. So and then from that date, I adjourn his prelim. The people are going to file their motion. I give a date today for the hearing of the motion. And then the day before, I get a motion to withdraw. And by the way, no answer to the motion.
You can clearly hear the frustration building in Judge Simpson's voice here. From the court's perspective, the timeline just doesn't make sense. The hearing date had already been scheduled, the prosecution filed their motion as expected, and everything was set for today. Then suddenly, right before the hearing, the defense office files a motion to withdraw. In court procedure, timing is everything. Judges rely on attorneys to flag potential conflicts early in the process so the court can adjust schedules if necessary. When something like this surfaces at the last minute, it throws the entire system off balance. Prosecutors prepare arguments, court staff reserve time on the docket, and other cases may be scheduled around hearings like this. The judge is also pointing out something else important. There was no written response to the prosecution's motion. That suggests the defense may not have fully addressed the issue before the hearing. So from the court's perspective, this creates two problems at once: a sudden withdrawal request, a motion hearing with no prepared written response. And that combination raises a serious question. Was the defense actually prepared to argue today's motion, or did the conflict issue derail their preparation entirely?
I completely understand the frustration from the court.
I don't think you do.
Your Honor, I was prepping for this matter up until yesterday. I'm just telling you where I'm at with today. There was a conflict check that I sent this week. I was appointed to represent him today. I sent that conflict check this week. So
On the new matter.
on the new matter, and yes.
So since you're still counsel of record, what do you suppose I do with his exam?
This preliminary exam coming up on the 21st.
Yes.
Your Honor, if it was up to me, I would request just a week adjournment to allow.
That's not the way the exams run. I understand that, but I've got a motion. They want to proceed by forfeiture. Who's going to argue that?
Your Honor, if I need to, oh.
Counsel told me what it was about, but I have not actually been those phone calls. So I will be overnight just.
Yeah, our office has jail calls, discovery.
Ms. Barroso, you've arisen.
Your Honor, the forfeiture motion is on the assault with the intent to cause great bodily harm less than murder by strangulation or something, not on the intimidation. We do not need the victim to proceed on intimidation because it is based on the jail calls. All we need is the officer.
This statement from the prosecutor introduces one of the most significant legal issues in the entire hearing: the forfeiture motion. In criminal law, forfeiture by wrongdoing is a doctrine that allows the prosecution to admit certain statements or evidence even if the witness does not appear in court. Why would a witness be absent? In many cases, prosecutors argue that the defendant intimidated or pressured the witness into staying away. If the court finds evidence of that misconduct, the defendant essentially loses the right to object to certain evidence that would normally require the witness to testify in person. Here, the prosecution claims the key evidence comes from recorded jail phone calls. That's important because jail calls are routinely monitored and recorded, and they often become powerful pieces of evidence in witness intimidation cases. The prosecutor is essentially telling the court, even if the victim doesn't appear, the case can still proceed because the evidence comes from those recorded calls. All they need is the officer who can authenticate and explain the recordings. This dramatically raises the stakes of the hearing. If the judge grants this forfeiture motion, the prosecution could move forward without needing the victim present in court. So the question now becomes, do those jail calls actually prove witness tampering? Or is the prosecution stretching the evidence too far?
I would say unless the public defender needs to withdraw from the original offense because of a conflict, that we proceed on a motion today, since he was prepping for it up through yesterday, and he responded orally on the record.
Is Tamika LaShawn Cooper a potential witness in this case?
She was not physically present at the scene, and it is my understanding, Your Honor, that the individual who the defendant called on the phone that was not 911 was the defendant's grandmother, not the defendant's mother. So she would not be a witness in any capacity in the assault GBH. She's just a potential co-defendant in the witness intimidation, which we have not brought charges against her in that case.
How do I have a motion that tells me that this is a witness in this case? And I just heard she's not a witness in this case. She's not even a potential witness in this case. That was the question.
Your Honor,
You need to, you know what, Mr. Mansour, I realize how that process works. So what I'm going to ask the jail to do is to take him back. You find somebody that can give me an answer to that. Now, so that we've had a bench conference in this case so that we're clear, and I think the court is correct, and it's just been said, the court is not going to sign or allow the withdrawal of the public defender in this case. Actually, because they had sent in the motion to withdraw on this case that's up today, which is the one ending in 12/12. Right. But I'm not permitting the public defender to withdraw because there is no conflict. Somehow there was some confusion. There will, I guess, potentially be a conflict tangentially, but I'm not going to get into that. But on the other case,
This is the judge's decisive ruling on the issue that has been disrupting the hearing from the start. After listening to both sides, Judge Simpson concludes that there is no actual conflict requiring the public defender to withdraw from this case. That decision stabilizes the situation immediately. If the court had allowed the withdrawal, the defendant would likely need new counsel appointed, which could delay proceedings for weeks while the new attorney reviewed the case. Judges generally try to avoid that unless a conflict is absolutely unavoidable. However, the judge also acknowledges something interesting here. He mentions a potential tangential conflict related to another case involving the defendant. That suggests the defendant may have multiple legal matters happening at the same time, and one of those cases could involve different parties or allegations that complicate representation. For now, though, the judge is drawing a line between the two proceedings. In this case, the public defender remains responsible for representing Mr. Kyle, and that ruling clears the path for the court to move forward with the motion hearing that was originally scheduled for today.
that Mr. Kyle has
12/25.
12/25. Have they made you aware that 12/25 is set for preliminary examination on the 21st? Okay. All right. So if you know that, I don't know if you have discovery, they're going to make sure discovery and all of the phone calls and everything get to you, Ms. Barroso. When we were at the bench, where she's going to make sure that that happens. Is that correct, Ms. Barroso?
That's correct. I'm just writing down her email address for me so I can make sure you get that to her.
I should be here on the 21st.
Yes.
And are you going to hold the hearing today on the other one?
Yes. All right. Very good. All right, I've read the, now back to the case 12/12. I've read the people's motion. There is no written response from the defendant, but you can go ahead, Mr. Mansour. Did you wish to respond to their motion to admit statements?
Your Honor, could I ask Ms. Barroso for a copy of the statement or the motion?
That's my personal copy. Do you need me to email you a copy?
Well, hold on, counsel. So, Mr. Mansour, because of the withdrawal, which may not have been the proper withdrawal, you're not prepared to argue the motion. Would that be a fair statement?
Your Honor, I would like to have additional time to be able to prepare. So
I think my question is a yes or no.
So, to answer that question, not 100%, but I can do my best.
Mr. Kyle, I'll let them explain to you what happened. All I know is we had set this, and I'm sure you recall you were here before me on that date, and I gave a motion date. People were supposed to have everything in. and that was going to be today, and then you have your exam set later in May on the 21st. What's happened, and I'll just explain it I'll let everybody else fill in the details, okay? But I'll just say, yesterday I received a motion for the public defender's office to withdraw on this case, right? My understanding is it was only supposed to be relative to your other case. Got it? So from what I'm understanding from what Mr. Mansour said on the record earlier, that he's preparing to handle this motion that I have set for today. But then once he's apprised and he doesn't make that decision that there's a conflict, he stops. While he's willing to argue it, I don't know that he's had the time to thoroughly go through it because he had to stop. Okay. Okay, to try to salvage this and not jeopardize, most importantly, the people's right as well as your rights, Mr. Kyle.
Here the judge shifts from frustration to problem solving. Even though the public defender will remain on the case, the confusion surrounding the withdrawal motion may have interrupted the attorney's preparation for today's hearing. And that raises a fundamental fairness issue. In criminal court, both sides must have a reasonable opportunity to prepare and present their arguments. If an attorney is forced to argue a complex motion without adequate preparation time, it could potentially compromise the defendant's rights. Judge Simpson is careful to emphasize that he must protect both sides. The prosecution, often referred to as the people, and the defendant. That balance is central to the justice system. Courts are not supposed to rush decisions simply to keep the docket moving. Instead, judges must ensure the process remains fair and orderly. So the judge begins considering a solution that keeps the case moving forward without putting either side at a disadvantage. That solution, as we're about to hear, involves adjusting the hearing schedule slightly so the defense has time to properly review the motion.
I'm going to do it this way. Timing won't be ideal, but I'm going to adjourn the hearing on the motion for forfeiture to the 14th in the afternoon. All right. Folks, the people here should, I think, be here. I'm going to go in the afternoon because you should be here on prelims in any event. So I'm trying to pick that date that causes, I'll be here anyway. So, and you ain't going anywhere. So you'll be here. Okay. So that's what I'm going to do. You understand that, sir? All right. You have any questions about it for me? Okay. All right. That's what I'm going to do. So I'm going to adjourn the motion. Your exam, which is really the most important part of this because it's already been adjourned, I'm keeping that on the 21st. Okay. I'm just taking this motion we were supposed to hear today, giving a few more days, let them get caught up, and then I'll hear it on the 14th. Fair enough? Yes, at 1 o'clock. All right.
And with that, Judge Simpson brings the hearing to a practical resolution. Instead of forcing the motion argument to proceed under uncertain circumstances, he adjourns the forfeiture motion to a later date while keeping the preliminary examination scheduled for the 21st. This kind of decision is a classic example of judicial balancing. The court recognizes that procedural confusion, especially involving attorney withdrawal and potential conflicts, can disrupt preparation. But rather than allowing the entire case to spiral into delay, the judge simply moves the motion hearing forward by a few days. That short adjournment gives the defense time to properly review the prosecution's arguments, analyze the jail phone call evidence, and prepare a complete legal response. At the same time, the judge ensures the more critical step, the preliminary examination, remains on schedule. That hearing will determine whether there's enough evidence for the case to proceed to trial. So while today's hearing may have started with confusion and frustration, it ultimately ends with the court restoring order to the process. The bigger legal battle, Whether the prosecution can rely on forfeiture and those jail calls will now be decided in the next hearing. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.